All right.
Yes, Sheila.
Good evening, friends, and a very warm welcome to SAMVAD's 4-part series on child forensics in child sexual abuse cases. SAMVAD stands for Support, Advocacy, and Mental Health Interventions for Children in Vulnerable Circumstances and Distress. It is a national initiative and integrated resource for child protection, mental health, and psychosocial care, located in the Department of Child and Adolescent Psychiatry at NIMHANS, or the National Institute of Mental Health and Neurosciences at Bangalore. It was established and continues to be supported by the Ministry of Women and Child Development, Government of India. It gives me great pleasure to welcome you all to this series, which has been developed as a part of a range of different initiatives that SAMVAD is conducting to mark 10 years of the child sexual abuse law, that is of POCSO. We are doing several events that aim at critical reflection and ways forward. This public series, in collaboration with the Child Witness Institute at South Africa, is one of our many events. So in order to take stock of the progress made under POCSO, chart out the challenges that require our collective attention, the objective of this series is to generate engagement and discussion on some of the key imperatives of the implementation of the law. These imperatives relate to issues of child victim and witnesses, interviewing, eliciting evidence from children, appreciation of evidence, forensic medical evidence, amongst other such matters. It is my pleasure to welcome Dr. Shekhar Seshadri, who will be our moderator today. Dr. Seshadri is a well-known and well-beloved name in the world of mental health, and indeed in the world of child sexual abuse and child rights work. He needs little introduction, but for formality's sake, he is the former professor of Child and Adolescent Psychiatry at NIMHANS, the former Dean of Behavioral Sciences, the former Director. Many of you know that Dr. Shekhar has been working on child sexual abuse issues for over 40 years now. Indeed, he initiated a lot of child mental health work in the area of child sexual abuse many, many years ago, and he continues to be an inspiration to us all. With that, I hand this session over to Dr. Shekhar.
Thank you very much, Sheila. Friends, the first part of this series will deal with evidentiary issues in child sexual abuse cases, the dynamics of grooming. Through part one, we will examine the concept of grooming and how grooming is used by perpetrators of child sexual abuse to vitiate consent. Since grooming is an essential element in most cases of sexual abuse, especially when there isn't an element of physical coercion to the abuse, it is important to identify the patterns and examine how this evidence can be introduced in court. Additionally, given the ambiguity in perceptions of grooming, we will try and understand the conceptual contours of this method of child sexual abuse perpetration. Friends, joining us today from the Child Witness Institute in South Africa are two experts on this subject, Dr. Karen Muller and Karen Holloway. The Child Witness Institute is a non-profit organization in South Africa, which has been working for over 23 years on the concerns of child witnesses in cases of abuse, violence, and victimization in cases involving children. Both the Karens have undertaken extensive research on matters pertaining to children in contact with the law, reformation of justice systems, and training of stakeholders in these aspects of justice and law. They have also trained judicial officers, police personnel, and other stakeholders in the criminal justice system in several countries in Africa and Southeast Asia. A critical part of this institute's work has included developing comprehensive court preparation programs for vulnerable child witnesses who are legally required to contend with an adversarial and often hostile courtroom environment. On behalf of the SAMVAD team, we extend a very warm welcome to both our esteemed guest speakers today. Welcome, Karen Hollerly. Welcome, Carol Muller.
Thank you very much.
Thank you.
It is also important to take notice of the fact that no serious engagement on the subject of child witnesses can be complete without a transdisciplinary approach to the challenges that remain. Therefore, it gives me great pleasure to introduce our chair for this session, Honorable Justice Dr. Shalini Phansalkar Joshi. Justice Shalini has formerly served as a judge of the Honorable High Court of Bombay. Among her various engagements, she has conducted several training programs for judicial officers, public prosecutors, and police officers on gender and law concerns. She has also served as a director of the Maharashtra Judicial Academy. We are privileged, friends, to be accompanied by Justice Shalini in this session, whose work on the socio-legal dynamics of child sexual abuse has offered a central perspective on the workings of the adversarial system and its impact on the adjudication of child sexual offenses. A recent book, Decoding Child Sexual Abuse, is a critical resource for any professional engaged in the work of responding to child sexual abuse. On behalf of the SAMVAD team, we extend a very warm welcome to her ladyship. I would now like to request Justice Shalini Phansalkar Joshi to share her opening thoughts. Justice Shalini. Ma'am, you'll have to unmute yourself.
Dr. Shekhar Sheshadri, Dr. K. John Vijay Sagar, Sheila Ramaswamy, Dr. Karen and Karen from Child Witness Institute, and all the participants. At the outset itself, I should congratulate and also express a debt of gratitude to Dr. Shekhar Sheshadri and the SAMVAD itself for organizing this important public series on the subject of child sexual abuse, because it is such a serious subject that one has to discuss it from all the perceivable angles, especially when child sexual abuse is a very complex concept. And out of that, the grooming, as we will be discussing in today's lecture series, is one more dynamic and complex, complex concept as such, which is as on today not much recognized either by the law or either by the interpretation in the judicial decisions of the same. Now, we have to understand that child sexual abuse, the popular concept, common concept is that it is brutal always, but it may not be so necessarily. And in subtle child sexual abuse, which on face of it does not appear to be coercive, compulsive, or forceful, but there are other dynamics working underlying it, and that is called as grooming. So grooming, when we understand, it is a form of abuse in that way, whereunder the abuser manipulates someone until that person or that victim is isolated, dependent, and more vulnerable to abuse. How he does it? I mean, how he does it? By building a relationship, initially which appears to be very soothing, trusted, and comfortable. But subsequently, if we know the real intention of the abuser behind building such a relationship, we know that ultimate object was to sexually exploit the child. So anybody can be a groomer, no matter their age, no matter their gender, no matter their relation with the abused person also. There are various techniques or dynamics adopted by the groomer to ensure that the child acts as per his or her will. That is the will of the abuser. The first and foremost method may be adopted by the groomer, and who is subsequently the child recognizes to be an abuser, is identifying the target, as we call it, or identifying the victim, who may be a vulnerable child. Vulnerable may be on account of the poverty, on account of broken family, or on account of several such aspects like disability also. And then after identifying the best possible target, he gains trust and access to him or her. And for that, several methods can be adopted, as we will see in the course of our today's session from the experts. Luring and inducement may be initially, so far as younger children, it may be in the form of showering the child with presents, gifts, creating a special bond with the child, emotionally manipulating the child by saying that we are having a secret relationship which you should not disclose with anyone. You are special for me. And after isolating the child, making the child emotionally dependent on the abuse, and then after initiating the sexual contact, then taking total control over the child. That is a process of grooming which has several effects and which are having, initially child may not understand because it is such a smooth process from the abuser's point of view. Why he goes for this grooming, why he goes for this tactics of grooming. Maybe one is because he wants to lower the defenses of the child. Another, he doesn't want the sexual abuse to be disclosed, because grooming affects the disclosure of such child sexual abuse. By the time child realizes that it was he or she was totally taken in control by the abuser, the child starts believing that he or she herself was responsible for the sexual abuse. So the self-blame, the self-guilt, all these elements operate when the disclosure comes into play. And therefore, the grooming has, apart from manipulating the emotional world of the child, also the side effects of deterring the child from going for such a disclosure. Now the question arises as to how this grooming can be introduced or can be considered when we are assessing the evidence of the child victim. Because so far as grooming is concerned, there cannot be any dispute or legal opinions that it vitiates the consent. Consent, when given under the wrong beliefs, under the wrong assumptions, cannot be called as a free and valid consent. We are having the laws under section 90 of IPC. The consent is defined in negative terms to say that if it is given under the fear or favor, it cannot be called as a valid consent. Whereas in case of sexual offenses, we are having explanation in section 375 of IPC, which defines the consent, which is introduced after the amendment in 2013 to mean an unequivocal voluntary agreement. When a woman by words, gestures, or any form of verbal or non-verbal communication communicates willingness to participate in the specific sexual act. proviso is also there to ensure that a woman does not, merely because a woman does not physically resist to the act of penetration, it shall not by reason of only that fact be regarded as consenting to the sexual offenses. But this definition is so far as the sexual offenses against adult women is concerned. And it is very elaborate and very wide. But so far as children are concerned, our POSCO Act, Protection of Children from Sexual Offences Act 2012, deals with the children. And who is child? Any person below the age of 18 years. So far as these children are concerned, there is no question of consent, because consent under the Indian Contract Act can be given only by a person who is major. And who is major? Only the person who is above the age of 18 years. Now, the question will arise if the consent is not of any relevance as regards the children, how the grooming will come into picture to affect the consent. Because so far as the children are concerned, they are not having any capacity to give the consent. That is what the law says, so far as India is concerned. And if they are not having any capacity to give the consent, there is no question of consent being vitiated and not to be considered. But now, as the POSCO Act has enhanced the age for consensual sex from 16 to 18, now the question arises so far as these children in this age group of 16 to 18, whether their consent was obtained because of the grooming, whether their consent was obtained without their understanding the nature and consequences of the sexual act. And all these issues, when we talk of the consent, are going to come in the picture. But so far as grooming is concerned, whether it is of a child or whether it is of an adult, it can happen in both ways, though more it may be in the case of children. But it can equally happen in the case of teenage or adolescent girl also. Just as a groomer can be an any person, any adult, irrespective of his relation, irrespective of the nature of relation or gender. Similarly, an abuse, a person who can be groomed by and be anyone. Even the adolescent and adult girls can also be groomed. Because the grooming is a smooth process in that way, as it is from the side of the groomer. Initially, the groomed person feels very comfortable to be in his company, to be in his, and doing whatever the groomers ask the child or that person to do. And therefore, in case of even the romantic relationships or what we call as love affairs, also such grooming can happen, and then the consent can become vitiated. So during this session, with the help of experts, we are going to explore these various facets of grooming and how they're evidentially valued in the course of trial, especially now, in under the POSCO Act, we are having section 30 of the Act, which sort of lays down the reverse burden of proof. So whenever there is proof of any sexual act being committed, it will be presumed that accused has done that act with sexual intent. So the victim does not have to prove the sexual intent. Now it will be for the accused to say that he has not done this particular act with sexual intent. And this special provision or reverse burden of proof, or whatever you may call it, is done only to ensure that even if the child doesn't understand the nature and consequences of the sexual act committed by the abuser with the child, the abuser very much knows that he has done it with sexual intent, and we may call it as a grooming also. And therefore, it will be for the accused to show that there was no sexual intent. So to some extent, we are in that indirectly trying to, but otherwise, we are yet not, the law is yet not recognizing this concept of grooming as such. And that's why it would be interesting to hear about the dynamics of grooming from our two experts. Thank you.
Thank you very much, Justice Shalini Fansalkar Joshi. Justice Shalini has given a framework about the dynamics of grooming, predicated on which is the whole issue that our two friends from the Child Witness Institute are also going to take us into a deep dive into the evidentiary issues in child sexual abuse cases and how the grooming component becomes part of an evidentiary issues. It's my pleasure now to request our guest speakers to begin with their presentation. Karen's.
Thank you very much, and welcome to everybody. We're going to be looking at the evidentiary issues, and I thought that when I was preparing this presentation, I was thinking, I started off with grooming and then went on to disclosure, went on to development. And what became very obvious was that it's impossible to look at grooming on its own. It is so linked to so many different other aspects, which is what creates possibly all the difficulties that the courts have. And grooming is difficult to show, difficult to prove, because it's really very much how we behave normally towards people we like. So what I'm going to try and do in the time that we have available is to have a look at all these dynamics and how they interplay. And I wanted to start off with just a quote from a 1995 case, long ago, but one of the first ones. And it's actually a Zimbabwean case where the judge made it very clear that courts are changing. Courts are changing in the sense that they're becoming more specialized in particular areas. And it is accepted that in order nowadays to come to any intelligent conclusion, the court is going to have to apply a certain amount of psychology and be aware of advances in this field. And I've always really liked this judgment because even though it appeared in 1995 and was regarded as quite earth-shattering, it explains very clearly this whole concept that we now have of working with the dynamics of children, abuse, and all of those dynamics within a legal framework, and trying to understand how they make sense. So when we're talking then about the context of abuse, we have to see it within a larger framework. And this, it does not occur in a vacuum. And this is really one of the difficulties that I find the courts have, because in a courtroom, the narrative is very confined to something that has happened almost in a vacuum. You know, somebody's been murdered, somebody's been killed, or somebody's been raped. We look for certain elements. If we're talking rape, we're looking for penetration, we're looking for certain body parts, we're looking for issues of consent or not consent. So our narrative has been reduced to certain factors that we look for. You know, is there consent? Is there penetration? Those kinds of questions. And because of that, we often come to incorrect assumptions, because we're looking specifically, our focus is specifically on the different factors as opposed to the story. And grooming is one aspect of that. And I've just wanted to give two examples just to identify what I mean here. Is when we have the party girl, let's say she's 15 years old, 15-year-old girl goes out to a party with her friends. She hasn't told her parents because obviously they're not going to approve. So she goes and stays with one of her school friends, and they organize a party. They go to the party, they have a drink because it's quite cool. I'm 15, I'm going through different developmental stages, which means that I'm going to act in a particular way. My brain development is at a particular stage, which means I'm going to do risky behavior. that is the context of this child going to a party. So if, for instance, at the party or coming from the party, she is raped, in terms of the context that we have, she's not going to disclose because of the situation. She lied to her parents. She doesn't want them to know what happened. She feels guilty because in her head, because she did this, it was her fault. She doesn't understand much of the way that she's behaved because she's an adolescent. So we're not going to get the whole story out of her because we don't understand the broader context. And this is, I think, one of the most important things that we need to understand. And it's why I have extended the discussion from just focusing on grooming, which we will come to, but to the fact that grooming is part of a context, part of a larger context. And that context is lost in law because our police aren't trained to look for evidence of grooming. They're trained to look for evidence of the act. So we look to see whether there is an act. We have no evidence available of what the backstory was, how this happened, why this happened. And that is the discord, or no, discord is not a good word. That is the dilemma we have between the courtroom and the context of the real story that has taken place. And we're going to have to change our head shift a little to look more to the story in these cases, as opposed to just the elements that we are trying to find. Another example would be, for instance, the teacher example. And I'm specifically using a male victim in this instance because our male victims are very often overlooked. This is, again, a situation where you have a teacher who you admire, who you really like. She gives you a lot of attention. She helps you. She makes you feel important. She makes you feel intelligent. And that whole scenario is what will contribute to me from a developmental level, not realizing what is happening, from a brain level, not being able to deal with the risk and the control issues, and not understanding that, in fact, this is abuse. And in much of the research recently, the recent research that has been coming out is that very many of our children don't even realize that what has happened is abuse because of the context in which the abuse has taken place. So for me, we have to be focusing very much on the context in order to understand the grooming, because grooming is only one element and it is applicable to all the other aspects. It's applicable to my development. It's applicable to my socio-emotional development, my cognitive development, my disclosure processes, my trauma, my understanding of the event. And I think just, we don't have much time, but today I would just really like to draw those links. We'd obviously need more time to go into each in detail. So I'm just going to highlight the links before we end off with looking at the grooming. So why are our cases involving sexual violence against children so complicated? Because they're so enmeshed in terms of the different aspects that are interlinked. We're talking cognitive development, and that is the grooming is going to be very much dependent on my cognitive developmental stage. If I am a 5-year-old, it's going to be so much easier to manipulate the child because cognitively, they are not aware of what is happening, and cognitively, they can't see the manipulation. Your adolescent is in a better position to see manipulation, but because the adolescent is going through other socio-emotional stages, they become confused. So the grooming is so key to all other aspects that it cannot be understood in isolation. And I think that's really the key of my message today, is that we cannot see it in isolation, because the grooming I choose is going to depend on the cognitive development of my victim, what their socio-emotional development is, what the family dynamics is, so that it affects the disclosure process, the trauma that they are experiencing and will experiencing. And all of those are interlinked in terms of understanding grooming in a more detailed way. So if we look at the stages of cognitive development, for instance, to start off with, your child's understanding of abuse is dependent on their development. So the younger child is not going to recognize the abuse as abuse as such. So it's going to be easier to manipulate them in terms of giving them gifts, of confusing them as to what the act is, manipulating them so that they accept the guilt of what the process is. Your older children are going to have difficulty understanding, more aware that the action is not acceptable, but having difficulty why the person is doing it, especially where the person is a good person or a person that they look up to or admire. So there is a certain confusion there, but developmentally I still have difficulty seeing that I'm being manipulated. And this is one of the key reasons why very young children who are abused often only disclose when they are adolescents, because they did not see the manipulation before, but now they're able to see it. Very good example, and it's important to see that grooming is not always necessarily just giving sweets or giving love or attention. Grooming is also manipulating. And if we, let me give you an example of what I mean. In one of the case studies that I was party to, it occurred in the UK. The accused was married. He didn't have any children, but his wife's sister, she was a single parent, and she had 2 young children. And these children would go home to the flat and wait there till their mom got home from work. So one day the uncle, the accused, suggested that the children come to his home and he will take care of them in the afternoon until mom finishes work, and then she can pick them up. Mom's very happy because now her children are safe. What he does then is he prepares the environment. So when they arrive home from school, he is watching movies, because kids love movies. These children are under the age of 9. The kids love watching movies, so he's watching movies. They'll have lunch, they'll watch movies. Mom comes and fetches them afterwards. Lovely afternoon. Then he slowly starts to introduce kind of very sexy movies, not pornographic, just very movies of people in bed together, those kinds of things, slowly getting the children used to that. Then he adds movies that are a lot more sexual involved. And then finally, he will occasionally add in a pornographic video. Because of my age of development, I'm not aware, and I don't see the difference between the pornographic one and the one where it's legally permissible. And then I become used to it. And he does this for a long time, for a few months. And he will keep swapping. He will normal movies, maybe a very sexy movie, then a pornographic movie, normal movies, and the kids are used to the movies. After a few months, when he's ready to act, he will then get the children the day on he's ready to act. He will, before they come home, he will remove all the movies that are not sexual, leaving only the pornographic movies there. And then he is in the kitchen when they arrive home, busy with something else. And they arrive home, he says, hi guys, I'm sorry, I'm busy here, running late, had something to do, but you go and choose a movie you like and you watch it. I'll make lunch so long. So they go in, they take a movie, they put the movie in. It's a pornographic movie, but they've seen it before, so they don't recognize anything. He waits for a while, then he comes in, and then he goes, "What are you guys watching? Why do you choose to watch these kinds of movies? What will your mother say if she sees that you choose to watch these movies?" And then he starts the abuse. Now, at that age, they won't ever disclose because they'd have to say that they chose the movie. Now, at that age, cognitively, they cannot see how they have been manipulated. Perhaps when they get to 12, 13 and look back, they'll be able to say, "Hey, but he showed us the movies first." But under the age of 9, I don't have that cognitive capacity. So this is the link I'm trying to address here, is that grooming is very, very closely linked to all other aspects of development. And in order to get that story into the court is where our difficulty lies. So in that instance, all we would have possibly would be the child saying that the uncle had fiddled with them and he'd done this to them. So we have the act, we have all of that act. We won't have the backstory about how he slowly got them used to watching movies. And that's the key to understanding the story of what has taken place. So in terms of this, it's just important to be very aware that there's certain elements of child development that make your grooming so much easier and which will assist in choosing the format of grooming that you use. Because young children are highly egocentric. They do not offer information spontaneously, and we have to lead conversations with them to access information. So because they do not have the cognitive capacity to see what's inside your head, they cannot see your manipulation. They cannot see that you led them into behaving in this way, and consequently, they can't offer you that information. And I've just put an interview up on the slides to show you what I'm talking about. With your 5-year-old, for instance, what happened? He hurt me. What did he do? He did stuff. What stuff did he do? The stuff with his hand. And I don't offer any information because cognitively, I don't know what information you're looking for. I don't know that I'm supposed to tell you how I was manipulated. I don't know that I'm supposed to tell you about the seduction, about how he got me to do what I did. And therein lies our difficulty, in that we are going to have to source that information because the child is not going to be able to do it. And your child's lack of being able to evaluate is what makes it so difficult for them to see what is happening. They can't tell you why people do things. They can tell you what people do. Okay. Again, in an interview with an 8-year-old, tell me what happened. I was standing at the wall, and he wanted me to come over. Why do you think he did that? I don't know, because you're asking an evaluation. Okay. And that's why your child is unable to explain the grooming to you. What made him call you? He wanted me to go to the shop. So when it's concrete, I can provide information. But when you're asking me to evaluate, it's impossible. And this is the difficulty we have in the courtroom scenario, because your young child does not understand the process of grooming. So they won't be able to provide the evidence of the grooming unless we ask concrete questions of relationships and what was necessary. And issues relating to time are also applicable, because as we know, under 12, our children don't have any concept of time. So being able to explain how this relationship developed over a period of time is going to be really difficult, if not impossible, for your younger children. In addition to your cognitive issues, we've obviously got language issues, which are going to mean that problematic from two areas. One area from the actual abuse, where sometimes I'm not even aware that abuse has taken place, and the manipulation, as well as the language development in the courtroom, where because of my limited cognitive ability, I don't really have the capacity to tell you the story and the way it unfolded. And even with your older children, your adolescents, it's going to also be difficult because very often the manipulation is so subtle that I don't see the manipulation. So if we go back to our example at the beginning of the teacher, I would not see that the teacher assisting me with work, the teacher assisting me by telling me that I'm working hard, that I'm clever, that I may be groomed. I don't see that as grooming. Your adolescent would be easier able to see grooming as gifts, where the gift is very obvious, then I can see it. But when it's still the subtle manipulation, I don't, unless I've been on a course to tell me what grooming is, I'm not going to be able to recognize the grooming and explain it to you. Okay, I'm just wary of time. The other aspect is the socio-emotional development, which is crucial to how we use grooming and how we access children at different stages, because our children do not exist in a vacuum. Okay, the stages of socio-emotional development is going to impact on their behavior in different ways, which is obviously going to be applicable to the way in which your abuser is going to choose what grooming style he's going to use. And it's really important to be aware of these stages. Again, this is going back to our quote from Judge Ibrahim. This is why adjudicating cases of sexual violence against children is a very specialized area, because we need a basic knowledge of these things to be able to identify when this there is the possibility of grooming or the possibility of misunderstanding. I've just put up the Erickson stages of development, and obviously we're not going to be focusing on all of these. I've chosen just some, for example, to show you how they link to grooming so beautifully. So if we look at adolescence, for instance, your adolescents are going through two very important developmental stages, namely finding an identity and also learning about intimacy. And those two are probably key to why it is so easy to access adolescence. If we look at identity, the identity stage, which children go through roughly between the ages of 13 and all the way up to 21. In this stage, I'm trying to discover who I am and where I fit in the scheme of things. What do I like? Who am I? What do I want to become? Where do I fit in? Am I one of the computer geeks? Am I a sportsman? Am I going to be one of the academic students? Am I going to be one of the party girls? Where do I fit in? Who exactly am I? And this internal crisis offers a wonderful opportunity for offenders, because when I'm trying to fit in somewhere, they can help me fit in. They can make me feel comfortable with who I am. They can direct me. They can tell me how I fit into a particular area. If I'm a sports person, my coach will tell me how well I'm doing, or my dance coach, and I will work hard for them, and I will admire them, and the relationship will build up really beautifully. And especially in your identity stage, because at this stage of development, from about 13 years old, our children are, as evolution would have it, are moving away from parents and becoming more independent. So the need is to move towards peers and others, and this is really a good place for grooming, because I, as a soccer coach, as a dance coach, as a whatever it may be, teacher, am able to fill that gap that was held by the parent and groom in that way. So the dynamics of grooming are so wide. They could be replacing the role of a parent. They could be stepping into the shoes of where a parent used to be. And my concern with a lot of the grooming that I have seen in the courtroom context is that we tend very often to focus on concrete grooming. He buys me clothes, he does this for me. Grooming can be, and often is, a lot more subtle than that, and can simply be the creation of relationships. So your identity is a problem, and it means that your adolescents are going through obviously very many emotional and physical changes, and this is going to also impact on their inability to disclose, because as teenagers they are very especially in early adolescence, very embarrassed, very shy, do not want to share, especially anything to do with sexual issues. Where we have boys who've been abused, boys who've been abused by men, society has huge stigma on that. So I'm rather going to hide or not disclose that, because I really, at my stage of trying to develop an identity, am not going to be able to withstand any kind of stigmatization in terms of that. So our adolescents are extremely vulnerable to this kind of grooming. And at the same time, of course, they're going through intimacy and versus isolation, which means they're now also learning about relationships. They're having their first really deep friendships. And as I said, grooming will fit in very beautifully into the development of relationships, whether it's a coach-teacher relationship, whether it's an older friend relationship. And I'm also at the stage where, because of sexual development, I am obviously more interested in matters relating to sex, to questions about sex. And it's so much easier to discuss this with somebody I'm close to as opposed to a parent. So your offender can fulfill a very good position in that child's life in terms of allowing boundaries to be moved so that we can discuss topics that we could not normally discuss with others. I could introduce you to pornography, show you that it's actually really not so bad. You know, parents are parents and they complain, but you know, this is what adults do all the time. And in that way, infiltrate your whole concept of relationships and what they are and your behavior in terms. So that whole cycle is so subtle that by the time I get to court, I wouldn't be able, I could say to you, he showed me pornography, but that's not quite the same as how he cleverly manipulated me to see the pornography as a norm, and interfered with the whole way I view relationships. Even as an adolescent, I wouldn't be able to evaluate that. So again, we have that problem. So what are the implications? The implications are that by using your normal developmental stages, it makes it very easy for your offenders to ensure that children don't talk. Because, and I perhaps should have started this session with that, is the fact that the most important thing for a sex offender, more important than anything else, is the fact that he has to keep the abuse a secret. Because if he doesn't, he's got a chance of going to prison. So keeping that abuse secret is vital. And yes, how do I do it? I do it with grooming. But it's not just grooming, because buying somebody a gift is not going to keep them quiet necessarily. It's about infiltrating. Oh, sorry, I don't know what's happening there. It's about infiltrating the way in which the child, sorry, my computer has just gone completely insane. Infiltrating the way in which the child is seeing his world and able to respond to his world. I'm not sure. Can everybody else see my screen, or because my screen has just disappeared?
No, your screen, your presentation is off, Karen.
I have no idea what's going on. Perhaps, Corin, you could just talk a little bit about the trauma of grooming while I just try and find out what's happening here.
Sure.
Yeah, I will do. Okay, so as Karen has mentioned, it is a highly manipulative process that is used by the offender to ensure the silence of the victim. And there's a considerable shift of responsibility in grooming away from the offender to the child or to the victim, him or herself. The offender will use manipulation to make the child believe that they are complicit, that they are enjoying the process, that they are benefiting from it in some way. By that, it means that the child will see their relationship with this person as a positive and then interpret that positive to mean that anything negative that comes from it is the child's fault themselves. And then we also have instances in grooming where the offender will specifically inform the child that the reason for the abuse taking place is because of the child's behavior. It is because the child placed themselves in that sexualized relationship with them. The offender often will manipulate the child into believing that the offender, was the victim and that the child was the one who was grooming them and making them participate in this process. This causes significant amounts of trauma. And of course, it's a very vital element of grooming for the offender to shift the responsibility and the belief towards the child that the child is in some way, shape, or form responsible for the abuse. Because as Karen mentioned, the whole foundation, the most important element of child abuse and child sexual abuse is ensuring the silence of the victim so that the offender, him or herself, does not get caught. So by shifting that responsibility to the child, by the child believing either directly as a result of what the offender has said or indirectly through them understanding or trying to understand the role that they have played with the offender, the child will take that on to mean that they have done something wrong. And we have had multiple cases where the child's trauma, the impact of the abuse, has actually been worse as a result of grooming than in fact the contact of the sexualized or other form of physical contact that the child has experienced with the offender. There is in fact a very good model that is used to explain the impact of grooming on child victims of particularly sexual offenses, but it can be used to explain other forms of violence as well. And we call this the model of traumagenics. It's not our model, it's a model that's used internationally to explain the depth of the impact of grooming on child victims. And the model of traumagenics is made up of 4 what they call trauma-causing dynamics. The first one being betrayal. And again, you can already see the link between how grooming can influence a child's sense of betrayal. So the grooming process, as Karen has mentioned, is a way of developing a relationship with a child in a way to transition that relationship into a sexual act at some stage. So the child feels that this person does love them. They feel that this person is fulfilling a need in their life. So when they realize that this so-called relationship has actually been an exploitation, it has been abusive, it has caused them harm, there is a significant sense of betrayal. And of course, it's not just around the sexual act itself, it's all the other elements of the relationship that the child develops a sense of betrayal over. So that sense of being special or being loved or getting specific attention, or if the offender has promised the child certain things. We had a case many, many years ago where the accused was a person who worked for the national television broadcasting company, and he was a musician, and he had a vast amount of music, personal collection of music in his home, and he targeted adolescent boys. And one of the things that he did to manipulate them into developing this relationship through grooming was to invite them around so that they could sit and listen to the music that he had, and he would introduce what we call taboo violations. So, for example, allowing them to drink alcohol, to smoke cigarettes, things that they were not allowed to do in their own homes. And there already we had the development of this concept of secrecy. So don't tell your parents that what we're doing here, because they will find out that you've been drinking, that you've been smoking, so it's our secret. Now, in that particular case, what he did was he introduced one of the boys to this system of grooming that he had, and he offered to make that boy famous. He was going to make him a famous musician. He was going to help him to make his own music, etc. And as the time progressed, the boy started to realize that that was not actually going to happen, and that it was just abusive. And it was through that sense of betrayal that his future, his career, his opportunity to become a famous musician was in fact a lie, that he developed this intense sense of betrayal. Sorry, did you want to say something, Doctor?
Yes, while Karen Muller is trying to get her tech stuff going, this was basically carrying forward, Karen Holloway, the issues that Karen Muller has raised, and which you built on this thesis. So what I thought we could do is that questions have already started coming in, which kind of beats together what has been said so far. The questions specifically were on this whole business of how do children actually identify grooming, and how do we create spaces regardless of gender for kids to report, particularly because child sexual abuse of boys has a lower reporting. And then, someone responded with this whole issue of the good touch, bad touch, and we do not believe in this paradigm. And we will explain to you why this paradigm is very problematic, because even adults recognize what good touch and bad touch is. That doesn't prevent people from trying to molest them. And
exactly.
sometimes what is traditionally called a bad touch actually feels good when grooming takes place. So Karen, the specific issue is that, as has been discussed today so far, evidence of grooming can be quite useful in the case of CSA. But one of the issues that remains is, how do we evaluate potential cases of child sexual abuse when the offense is still at the stage of grooming and there has been no sexual contact with the child? Let me explain this a little further as an example. The UK, as I'm sure you're aware, introduced grooming as an offense in the Sexual Offences Act 2003. And it covers the behavior of an offender who meets or seeks to meet a child with the intention of committing a sexual assault. And this is what Karen Muller said, when grooming can simply be the setting of a relationship. No touches occurred so far. So if he has met or communicated with the child on at least 2 earlier occasions. However, one of the criticisms in the UK has been that proving intent in a grooming offense where sexual contact has not been initiated is quite difficult. And one of the difficulties in this early stage of grooming process is distinguishing between friendly behavior and grooming. And indeed, it is possible at this stage that there is insufficient evidence to even prove sexual harassment, which does not require sexual contact. So how do you respond to these concerns, Karen?
It's a very good question. And obviously, it is highly dependent on what your legislation does see as being criminal. But from a grooming perspective, what we look at is we try and broaden our understanding of the range of inappropriate behaviors that constitute part of the process of grooming. And by that, I mean, we look at both non-contact as well as contact abuses. Now, if you look at non-contact and contact, your non-contact, obviously, by its name, means that there is no direct physical touching of the child by the offender. However, he is or she is still using methods to desensitize the child around later sexualized contact. So your non-contact abuse includes things like voyeurism, flashing, introducing the child to pornography, or any other kinds of visual depictions. And I'm going to give you an example of a case that I did that will help you understand this. Inappropriate language or suggestive language. So that really constitutes what we would think of in terms of pornography, of non-contact abuse. And I think it's a very important question as well, because of the elements that we find on online abuse. We also have online grooming, where the child is never necessarily touched by the abuser, but there is grooming. So in a non-contact version of sexualization of the child, we're looking at, as I said, the main intent behind that is to desensitize the child and de-stress the child around the issues of learning about sex and becoming sexualized. So I had a case many years ago where the offender was a lecturer at a university and he was the computer lecturer, but he was also a karate instructor. And he targeted adolescent boys in his community, and he targeted specifically adolescent boys from single parent families who were vulnerable. So he set up a karate clinic, and he offered to teach the kids karate for free. And he would have them during the week. And I mean, I watched all the video footage of this. So he did a brilliant job. I mean, he had award ceremonies where he would hand out medals to the boys. He would video the actual karate sessions. Every Friday, he would invite some of the boys or all of the boys around to his house where there was a swimming pool, where he would then, cook a meal for them and they could have fun. From the outside, it looked absolutely spectacular. But in terms of the non-contact abuse elements that he used, for example, as I said, he had a swimming pool. So when he invited the boys to his house, he would get the boys, remember, these are now teenagers, they're young teenagers. So he targeted between 13 and 15 years of age. He would get the boys to line up at the side of the pool without their shorts, without any clothes on, from biggest to smallest penis. Now, that might sound very bizarre to anybody, but if you're understanding grooming, to the boys, it's a fun game. It's part of the brotherhood of boys, right? But to him, what is he doing? He is desensitizing them to being naked. He's making them familiar with being around each other naked. He's making it fun. He's making it okay. And by doing that, he is introducing these elements of sexualization, comfortable being naked. Those are the things I'm talking about. The other thing he did was he obviously showed them pornography. Pornography is a massive non-contact abuse trigger for us when we're looking at grooming processes, because if you look at child development, your children often don't know what sex is. Now, your offender's main goal is to be sexualized with the child. He's got to teach them what that is. How do children learn? They learn through books, they learn through pictures, they learn through stories. So books, pictures, and stories also come in the shape and form of pornography. So it's a very useful tool for an offender to teach children and again desensitize them towards the issue of sexuality and sexual behavior. Another very interesting thing that this guy did was that he thought he was a bit of an artist, and he had a table in his house, one of those steel tables that you would find in a hospital, and he would get the boys to lie on the table, and either he would stimulate them or not, and then he would take plaster of Paris and he would pour it over their genital area. It would harden, and then they would take it off and they would decorate it together. So when the police raided his house, he had all these molding casts of boys' genital areas with bottle tops and colors and paint and all of that kind of stuff all around it. So yes, I do understand it is difficult if the contact abuse, and by contact abuse, I'm talking about what we all know of as sexual, oral sex, digital penetration, penile penetration, all the things that we understand constitute a sexual act. And if you don't get to that, it's very difficult to be able to categorically say that the behaviors preceding that are an indication that that it is grooming that's happening and not just a friendly relationship being built. But if you have a case like that one I've just explained to you, all of those non-contact abuse experiences by an expert such as myself could be explained to a court to be able to say to them that, in my opinion, based on what is known about grooming, that non-contact abuse behavior could possibly be an indicator that this was grooming taking place. So I hope that answers.
Absolutely. There is one more related question, Karen, to which your responses would be very useful. And then we will take some closing comments from Justice Shalini Joshi. You remember Karen Muller spoke about the soccer coach, the dance coach, and you speak about the karate coach. And one of the difficulties with grooming is also the fact that there exists familial grooming, like in the case of Larry Nassar and the US Gymnastics Association as well. So institutional grooming in cases like the Royal Commission's investigations over 1,100 child sexual abuse complaints over 35 years against the Anglican Church in Australia, another example. So how do we understand familial and institutional grooming from an evidentiary standpoint?
I think, that's also a very good question. And I think we have to look at it again in terms of the collective behaviors that constitute. Remember what Karen said when she started off with her presentation. We need to look at the narrative. We're so busy focusing on the legal elements of crime that we forget to see the context in which it happens. Because you also have not just institutional grooming or familial grooming or grooming of the victim, him or herself. We actually refer to those as a collective as environmental grooming. And environmental grooming is, I'm not just going to target the victim, I'm going to target the victim's context. So I'm going to befriend the single parent mother so that I can have access to her child. With the churches and the sports situations that we see where there are high numbers of children that are targeted, we have to look at the whole context of the relationship of the offender, not just with the child, but with the context in which the child finds him or herself. So once again, we are going to be looking at the elements of relationship building. How do these institutions, how do these families as a whole, how do they form part of the narrative that is essential to understand how we get to the end point of the child being exploited and abused? So I don't know whether I've answered your question, but I think it's very important that we do keep looking for more than just the elements of the crime. We need to look at the context. We need to look at the story. We need to look at how many people were involved in a relationship that created an opportunity for this person to be able to have access to the child. You're on mute, Doctor.
Thank you very much, Karen. I see that Karen Muller has joined us back. Karen, any last thoughts that you would like to share with us before we go to Justice Shalini for her closing remarks? We have been talking about familial and institutional grooming from an evidential standpoint. We've been talking about where contact has not occurred, but in the grooming process itself. And we spoke about the UK's Sexual Offences 2003 Grooming as an Offence Act. We spoke a bit about some of the online stuff. Typically, when we talk of grooming, the image that is conjured if the of an online sexual predator engage in sexual conversation with the child. So the perception is that of a predatory stranger. But research has shown that the majority of abuse takes place by trusted and known people and typically takes place in person. So some thoughts, Karen Muller, that you would like to share as your closing thoughts?
Hi, thank you. Sorry about that, but my computer crashed and I had to go and steal my daughter's to try and get back on. Yes, I think the most important thing for me is to make sure that we see grooming as much more complex, and that it involves so many different other aspects. And we need to link it to an understanding of child development and cognitive development and trauma if we are going to make better sense of it.
That's a framework that one needs to keep in mind of the complex nature of grooming and look at its relationship context, look at the series of interactions that have taken place, and depending on the age and the cognitive level of the child, conduct your inquiry in a way that evaluative questions are not asked, but narrative experiences are recorded. And that forms the framework of the evidentiary from an evidentiary standpoint when the case actually goes to trial. Thank you very much, Karen Muller, for this very useful framework that has been provided to a large number of audience who've been present here today. Justice Shalini Phansalkar Joshi, your closing remarks on the whole issue of evidentiary issues in child sexual abuse cases and the dynamics of grooming. Justice Joshi.
Yes, thank you, Dr. Sheshadri. And Dr. Karen and Karen, it was really wonderful to know the various facets of grooming. I mean, we really don't understand the grooming as such because it is more or less a psychological concept. Sitting in, as you have rightly said, in court, we don't have the space for context or other aspects of psychological things. Which questions to be asked to the child to elicit the best information the child can offer is so important, because the answers will depend upon the questions we ask. And therefore, in order to ask the appropriate question, proper questions, it is necessary to understand this entire process of grooming. And it is, as you have rightly said, it is very, very complex and difficult to, unfold this through the evidence of the child as to how he has been subject of this grooming and how the entire incident has occurred because of the grooming, which are the previous stages which ultimately led to the sexual act. And how, and as Karen has rightly said, that sometimes the grooming is having far more impact, damaging impact on the child than the abuse itself, because it really destroys the emotional world of the child. The child has built up some emotional bonding with that person, maybe, and that is having the reason for the, abuse itself. We had some cases of institutional abuse where the grooming was I mean, one of the case was of Freddie Pitts in Goa, where he used to bring the street children and those roaming on the street to his orphanage, and there he used to abuse them, initially introducing them first with the gifts, with the good food, and thereafter conducting all these, all sexual acts, showing them pornography, making them do these acts. We had another case in Mumbai also, where the orphanage was run by the two UK residents who were in India. And there also, on the basis of the evidence, which was, I mean, really important, which was collected, the conviction could take place. But the question is whether we had gone deeply into this process of grooming, because ultimately it has resulted into the sexual act, because children were voluntarily coming to these orphanages. Children were enjoying the food and the attention which was bestowed on them. And therefore, the process of grooming, it was, it is such a basic and important aspect of child sexual abuse. I'm really thankful to both Dr. Karen and Karen for giving this enlightening address on these various facets and evidentiary standards of introducing and which questions to be asked and how to explore the mind and the entire situation, the entire environment in which the incident has happened, whether she is a party girl, whether a teacher, whether the karate teacher. I mean, sometimes you don't go so deeply into these aspects, but they are very important to reconstruct the entire incident and to heal the child from what is happening, because child ultimately ends up in the self-blame, self-guilt. In order to get rid of those feelings from the child victim, it is important to understand this process of grooming. So thank you so much. And it was really an exploring and eye-opener session for all of us.
Thank you.
Thank you very much, Justice Shalini. Friends, in essence, where evidence is concerned, the point that is being made is that the question is not merely what happened at 7:50 p.m. Indian Standard Time on 15th of March, 2022. The question is all the experiences, conversations that took place in the days, weeks, months, and sometimes years that preceded the first time that is physical contact, sexual activity was actually initiated. And as we have understood in the grooming process and the clever and pernicious way and manipulative way that it takes place, a motivated abuser and perpetrator may spend months in setting up this grooming process. And all that has evidentiary value. And therefore, for those of us who work in the area of child abuse and in the transdisciplinary context of child sexual abuse forensics, it is important to recognize that evidence gathering is about all these processes as well, because that is what really strengthens the case when an issue goes to trial. This brings us to the end of the first session in this series, which is part of our critical reflections and ways forward in 10 years of POCSO. And it is my pleasure now to hand you over to Sheila Ramaswamy, the technical and operational lead of SAMVAD, to close the session. Sheila?
Thank you very much, Dr. Seshadri, for moderating the session. Our grateful thanks to Justice Shalini, as always, for obliging us, for joining us. And of course, to our very, very special guest speakers, Karen and Karen from the Child Witness Institute. Friends, it's not over yet. We have 3 more parts to this very exciting public series. Our next one is this Thursday on the 17th of March, same time, 6:30 Indian Standard Time. The second session is going to be on suggestibility and tutoring concerns in court preparation programs for child witnesses. Again, this is a very provocative topic. There are very many views on this. The judiciary especially holds some very interesting views on this. Much to discuss and debate, and the Child Witness Institute will lead us once again through this complex issue. The session will be chaired by Justice Madan Lokur, again, whom you all know very well. Former judge of the Supreme Court of India, former chairperson of the Juvenile Justice Committee of the Supreme Court of India. So we look forward to the second talk in our public series on Thursday, the 17th at 6:30 Indian Standard Time. And until then, thank you once again to our esteemed speakers. It's been such an enlightening and interesting evening. We look forward to having you all once again on Thursday evening. Until then, stay safe, stay well, and good night from SAMVAD.